Well, tonight is legal issues, which is so exciting. I see the house is packed. But the first thing I have to do is the disclaimer. Always have to have the disclaimer. Real purpose tonight is to, a couple things. One is to make you aware of some of the legal issues you'll face in launching a new venture so that you're aware of what they are. Law is always very fact dependent. And so you can't absolutely say in every case the result is X, but you should at least know, what the issues are so you can spot them. I'm going to mix tonight the legal issues with some more practical stuff also. One of the classic things about lawyers is they will give you accurate answers. And the question is, are they helpful? All right, perfectly accurate answer, and you don't know what the heck to do with it. So I'm going to try to mix in some sort of business aspects of the legal things. And then we're going to cover a whole bunch of other sort of practical related things, and especially into the finance area. Thanks to Yoast, which I thought was a good idea, you can't read this right now probably, but what I've done is I've thought about life cycles of the business. So you have the idea stage, and then the pre-financing, outside financing, initial outside financing, Series A, meaning more formal, and then later financings. And then down the left side, intellectual property, legal entity, a variety of people-related things in financing. And I thought I would sort of organize that. I thought it was a very good idea because it sort of helps you understand this point and when it can happen. So that's sort of our timeline. But these will be up on the website, certainly, hopefully by tomorrow morning. So, all right. So the first part is, let me see if I can get this so I can read it. At the idea stage, looking at intellectual property, you have an idea. The question is, who owns it? One could be your employer, which relates to the issue here of exiting. And it could be MIT, there could be co-workers, or there could be independent contractors. And then the second part about that is so you got the idea and you want to make sure, does somebody else have rights in this idea? And if so, who and how do I get out of that? And then assuming you do have an idea where you don't have to worry about that or you've taken care of it, what do I do to protect what I'm doing? So that's the first part I thought I would go over. So just to talk about intellectual property, it helps translate your technology into a real business. This Fiona Murray puts this together in her tech strategy workshop. There's sort of 4 key areas for startups to think about. The first is intellectual property, controlling the knowledge underlying the invention in terms of what can be successful. The second is secrecy, that nobody else knows how you do it. That's one way to protect the advantage you have. The third is speed. You heard Steve talk about it last night, speed to market. Now, in some domains, speed to market trumps just about everything else. And I think that's where Steve's environment is. If you're the second guy with a switch and everybody else is already deployed, in his market, he was selling to large service providers or telcos. And once they standardize on a piece of equipment, they might second source that, but you're not going to be able to displace somebody easily. So for him, it was speed was the thing, even to the extent that maybe patents didn't mind as much. And then the fourth is locking in customers. Is there some way in which you do something with them that makes the switching cost high? And so those are 4 things to think about as you're thinking, as I develop the business plan and how I'm going to deploy things, which of these do I go after? Now, IP itself can help your business plan. It's a valuable asset. If you have it, it is something that you want to highlight in a way that it increases the perceived value of your company when you go out to raise money. There's also correlation with success. The company I run is co-founded, is called IP Vision, and we are actually a one of the things we do, we're a venture partner in a late-stage venture capital fund. And so this is a fund that would have earlier stage companies coming to it for money, usually before the IPO, or maybe the last major round before a major expansion. And at that point, if technology is important to their business, they should have some sort of intellectual property. If you're looking at, do I want to invest in this company? And the question was, could the analytics that we do help make better investment decisions? And we developed some screening mechanisms and things based on just public data. And we actually use that to help screen investments. And not only that, but to go back to earlier stage venture funds and say, because we could see who their portfolio companies are, and say, when that company is ready for a round, we're interested in it for these reasons. So we decided to, we've been working on using this for a couple of years, and we decided to see, is there any correlation between the IP, in this case patents, that these companies had and investment success. So what we did is we took 700 companies that were in 5 major venture capital funds portfolios. So Kleiner Perkins, New Enterprise, Domain, Arch, and I forget what the 5th one was. And these were companies where we could tell something about the economics. So they had either been acquired, gone public, or were out of business. So we said acquired and gone public, that's success, and out of business is failure. And we looked at the analytics that we ran on it, and it was sort of interesting. Now, for a venture firm like Kleiner Perkins, how many successes do you think they have for every 3 investments they make? 1. I mean, they're probably have been traditionally the world's best. They're losing their way a little bit now, I hear. But so they would have 1 success for every 3 investments. Now the question is, if we looked at the IP and we said, if we took the top quartile of the ratings that we did, based again on public data, what percentage of those do you think were successes that had gone public or been acquired? If Kleiner Perkins wins, remember they have money, talent, they manage, they have connections. And they win 1 out of 3 times. If I ran my analytics over a portfolio of companies and they scored in the top quarter of my rankings, what would you be impressed with? Well, this is correlation, it's not prediction, but yeah, so what percentage of the ones that were in the highest rankings, the top quarter of our rankings, were successes? If Kleiner is 1 out of 3. Yeah. Any other guesses? It was 85%. 85% of the ones that scored in the top thing. Now there's some methodological issues. The point is that there is correlation between, well, there it is, I told you, it's 85% were winners. It may be that what we're measuring is where IP is important, the people that manage it well are successful. It may be a surrogate for good management. But the point is this is starting to get traction with investors. So they're going to be looking at IP that you have and trying to figure out, is this good stuff, and are you guys geared up to manage it because they've seen results like this. Was there a question? Yeah.
What were the rating metrics?
There was something that looked at the amount of IP. There was something that looked at its relative position in space, in space-time. And then there was some surrogates for how well or whether did there appear to be a good strategy in managing it. And so 3 factors. So my point here is an interesting thing. I'm happy to give you the paper that came out. It was done with a Morgan Stanley senior guy. The point is investors are looking at IP more carefully now. So for companies where IP is important, keep that in mind. And you can also establish your management credentials if you are dealing with IP in a way that's thoughtful. Tomorrow, Jonald's going to come in, and he's going to tell you about some of the interesting things he did in developing his portfolio, and you can remember this slide at that point. So for those, this is sort of where we get to the basics, forms of intellectual property that we'll talk about here. One is none. There's no protection, or I don't choose to protect it. Trademark, copyright, trade secret, patent, and combinations of protection. So for example, software is protected, can be protected both by patents and copyrights. The trademark and copyright protections can enhance value, but they don't really block others from doing anything, right? So Coke has a trademark on its Coke, and a trade secret, which is the next one, prevents people from actually making the specific Coke, Coca-Cola. But neither of those prevents Pepsi from going into the market and coming up with something that's cola-like. And patents can cut both ways. We'll talk a little bit what protection is, but patents can actually prevent other people from doing what you're doing. So let's dig into it a little bit detail. Trademark or service mark. Now, a trademark is a symbol, a phrase, can even be a color, and it's in fact even been held to be a sound that associates in the minds of the relevant consumer the sources of that product. So does anyone know what sound has been trademarked? I don't know if Intel, that's a good one.
The Facebook pop?
That'd be a good one too. I'm thinking a little more bigger device. What has a very distinctive growl? Harley Davidson has a. If you put out a motorcycle that sounds like a Harley, you're infringing their trademark. So what it is, it's a way you're associating in the minds of the consumer or the relevant audience a source of what you're doing. And that's a trademark for goods, service mark for service. Examples of marks include house marks like IBM or Virtual Ink. Those people might think about it. Product marks. So IBM makes a ThinkPad. I guess now Lenovo has that. And Virtual Ink's product was Mimeo. So when people see Mimeo, presumably they think Virtual Ink. The rights to a trademark arise just in using them. And you don't really have to register, although there is some benefit to registering federally. If you, the famous case of McDonald's restaurants sued a restaurant in upstate New York, several restaurants, a little chain, also called McDonald's Restaurant. And McDonald's had a federal registration on the marks, the name McDonald's. And the upstate New York one won because they had operated before McDonald's did in that area. And so they're called a senior right, and they can continue to operate just in that area. But McDonald's, by registering nationally, could prevent them expanding anywhere else. If you go down the trademark thing, you want to pick a fanciful name. So Apple for a computer. Who would have thought that? iPad, iPod, Mimeo. You don't want to, in fact, you can't really get a trademark on something that's just merely descriptive. So analog devices, even if they got a trademark, it's not really a strong mark. How do I say that differently? Kodak, in its heyday with film, if you register trademarks in fields of use. So, and Kodak is such a strong mark that if I went and tried to open up a pharmacy, saying Kodak Pharmacy, it would be much easier for Kodak to come in and say, well, that's going to confuse people because, you know, we sell our film and our services through pharmacies. Other examples of where different marks have worked is Lexus. Do you use Lexus in library research? And Lexus, the car. And the question there is, would people be confused as to who was providing it? And there was a big litigation around that. So you want to try to find something unique that is fanciful, that you can get a strong mark on. And you can actually go search to see at the U.S. Patent and Trademark Office, USPTO, U.S. Patent and Trademark Office.gov. And you can search to see what marks are available. I would focus on the product or service if you're going to try to trademark something, and not so much on the company name, because for Tide detergent, you probably don't even know who owns Tide, but you know the detergent. Spend your money. It's easier to spend your money on trademark protection than trying to file your corporate name everywhere. Any questions on this background? Okay. Yep.
Apple actually licensed, they made an agreement with Apple Core Records with the Beatles.
Right.
And then the agreement was that as long as they didn't get into the music business, it was fine.
There you go.
Before the iPod and iTunes and everything, and then when that came out, there was a big legal thing until they got that settled. So, because you never know what business you might get into.
Right. And the other thing you have to do is once you establish a mark, you have to police it. So if you let people continue to use your mark in a way that's inappropriate, you'll lose it. So the way to think of a mark is you would use it in a sentence. A Kleenex brand tissue, a Xerox brand photocopier. The problem is when people say, oh, Xerox that, or do you have a Kleenex? I mean, that's where those things can actually become generic and they lose their rights in it. So trademark is something, if you can use the word brand after it, it's the right way to do it. Okay. Copyright. Copyright is the right to prevent others from making copies. And it arises from creating a work. You don't even have to register it. So if I write a letter to my mother, I have a copyright in that. But registration has some value when you get it. You have to register it before litigating. And you want to start using, to let people know you have a copyright. So if you see at the bottom of my presentation, I have a little C in the circle there. That's copyright. That says I have declaring a right in that. Yeah?
There are occasionally years or year ranges in the copyright thing. Why are the year ranges and why are they?
Well, you're trying to show the periods over which you've used it and helps establish when your rights arose in it. So it's, you're really supposed to show the whole year. Here I just did this year. I probably should do a whole 25 years if this slide was used during that period. Microsoft has sort of dropped the years on some of their copyrights. I don't quite understand that. What it protects, though, is preventing people from copying. So it doesn't protect the idea. So if you go to the area of literature, there have been many plays and novels about love triangles. Shakespeare did, a whole bunch, and other people. And if he could prevent other people from using that idea in a literary work, that would greatly restrict the availability of literature. But what he can do with a copyright is prevent somebody from literally copying it. Now, if you had two people simultaneously or independently writing exactly the same thing, that would not infringe a copyright, one to the other, because if they hadn't actually copied. Ways people show copyright infringement, I used to represent a map company. They would actually put streets that didn't exist in the map. So if somebody actually copied the map, they had evidence of it, or street directories. Or in code, sometimes you put non-functional software. Nobody would have thought, why is this code sitting here? It doesn't do anything, or it's commented out. And so it would be so unbelievably, the last Red Sox Yankees score in the middle of the code would not exactly be what a programmer would put in, evidence in copyright. Now, it arises in creating a work. The author of the work is the owner, except in two situations that are important. One, an employee who authors something in the course of employment, that copyright is owned by the employer. So if you write code, if your job is to write code for a company, your company owns it. The second one, without any further action, the second one is if it's a work for hire. And this becomes important in a couple ways for startups. One, a work for hire is where you hire somebody to produce something for you, and it's under a written agreement that says that they are doing that, and typically it says, and you'll own it. So I had years ago a client who had spent close to $500,000 with an independent contracting company to write a, I think it was a import-export, process system. And he found, after he paid the money, that the independent contractor was selling the system to other people. And he came to me and said, I paid for this. They can't do anything. They can't be doing that. I own it. I said, turns out you don't own it because you didn't get an agreement that says you owned it. So he paid $500,000 to put the code out there for other people to use. So in the course, before you set up your company, or even today, at my company, we use independent contractors. We have agreements that explain that whatever they write, we'll end up owning. And so you want to make sure that you have those, because when investors come in and they get all excited after Steve gives his big pitch like yesterday, they're going to come in and they're going to start scrubbing around and trying to see if you've got everything nailed down. Yeah?
Employee is paid by a company to do some coding, let's say, and so all the code that he writes belongs to the company. But then on the weekends or at night or something, on his own time, so to speak, he does his own thing. Then who does that belong to?
Well, it's within the line of what the employer is doing. It could very well be owned by the employer. In fact, it's typical for most technical people to be asked to sign an inventions agreement that spells this out in more detail. Have people signed that? Yeah, so it says, usually it says, first of all, I agree to keep everything confidential, which you actually have an obligation to as an employee anyway. You can't go and blabber your secrets of your company, but they make you specify. Then they say if you invent in the course of employment, and then they try to explain how that's going to work. And there'll even be an agreement that says, because if it's an invention that's patentable, the patent will issue in the name of the inventor, and so the company actually needs to have it assigned to it. But those agreements are trying to nail that down. Now, if you're coding a supply chain management system as your day job and writing computer video games at night, that's totally different. But if you're writing supply chain stuff during the day, and on the weekend you're doing your own version of that, maybe a web version of old code, you've got a set of issues there. And even if you can sort of sneak out, without getting caught, when the investors come in and they say, well, you worked for this company and you did that, so how come you have a release for this code? So those are the things you need to think about in the process. Yeah.
So if I have an offshore technology development company and they have leveraged or copied code, and I end up paying for their services, I can put the language in the contract that I own it, but what if it turns out other company owned it and they leveraged it? So how do I guard against this pitfall?
Well, as between the two of you, they're agreeing that you're going to own it, and if in fact you don't own it because they screwed something up, then you have a contract right back against them. It means you can sue them for failure to deliver to you ownership. Now, it gets tricky. If your business is writing code, you've got the typical thing when I see, I've got these agreements or these, we do a joint venture agreement or something, and they say about how Google is going to own all the code you write, and we're not Google employees. You say, no, that can't be, because programmers use stuff. They develop tools. They may develop standard modules that they sort of assemble to deliver something. And I bring a bunch of these tools to the party, and I'm going to write something for you. You can own the resulting thing that I do, but you don't. I retain the rights to the underlying tools. In a sense, you have a license to use that and to resell it and everything. But I can't lose my business by giving you all rights and everything. And so that's. Hopefully you get a sophisticated person on the other side that understands how software is actually written, as opposed to a lawyer there who says, well, we're going to own it, and you end up having to go around in circles. Finally, open source is a big issue, getting more attention. When you use open source, you have the general use license. You have to make sure that you're following that. Otherwise, when the due diligence comes and they find out you've got open source stuck in the middle of your code, that could kill a deal or make it I mean, it could kill a deal. I've seen it happen. And I think, is it Black Duck that still does the, there may be others, but I think Black Duck was a way you could determine whether open source was in any code. Okay, any questions on copyright? Okay. Trade secret means you keep it secret. Formula for Coke is the classic. Apparently, nobody knows the formula. It's kept locked up. The protection varies from state to state about what kind of protection, and it lasts as long as you keep it secret. So you usually want to get, well, you want to get non-disclosure agreements if you're actually going to disclose the trade secret. For your business plan, you certainly don't want to ever in a business plan describe all your technology at a level of detail that people can actually figure it out. That's part of due diligence, because you don't know where that document's going to be. Well, I think I'm going to talk about, to assemble tonight to try to address Jost's idea of the timeline, I assembled things from a couple different presentations, and hopefully I can't remember whether I put something in about non-disclosure agreements and how to read them, but maybe I'll come back to that. Yep.
Talk about how VCs will not sign NDAs, they just don't do it, and
Yep.
you know.
So VCs don't sign NDAs, they just don't do it. Well, why don't they do it?
Well, they see hundreds of deals, right?
Yeah.
They can't, you know.
All right, so a lot of stuff they see is sort of evolutionary. And so you come in with an idea and we're shaking our heads and thinking, well, I sort of get it. And then, 6 months later, I've seen a couple other pitches and I sort of finally get it. And, he looks like a better candidate than you. And so I don't want to be tied down the fact that, I signed an NDA and you come after me for that. Again, if you go back to Bob's presentation and even Steve's, he says you're not really selling the technology, you're selling what the benefits are. So if you have to actually tell them all of the excruciating details of your technology, then you probably haven't figured out how to pitch it correctly. Sometimes you can get people to sign NDAs by pointing out that you haven't actually patented yet and that you need the NDA for reasons I'll talk about how the patenting system works, and I've seen people sign them because of that. The choice, somebody said when to patent and when not. A classic distinction between patents are expensive, as you'll see, and if you have something that's a process, manufacturing process, it's often difficult to prove that somebody used your process to produce something. So I get a patent on the process, and it's a way of making a golf ball. I think that was a classic case. So I look at the golf ball, I can't tell, except maybe nobody could make it that cheap, that there's nothing in the golf ball itself that explains how it was made. So it's very hard for me to come and say that you're using my patented process. So in process technologies, it's often kept as a trade secret, just because of the difficulty of it. Okay, yep.
Does the NDA has any
As what?
the NDA? Is it enough? Because I heard sometimes it's worthless. Litigate or go through the court.
Well, it costs money to. You have rights, and then you have the cost to enforce your rights. And so any rights you have may not be worth it. If I bump into you in the hall, I've committed a battery on you, but to sue me for that, you're probably not going to do that, right? Because so there are rights you have, and then the question is, do you enforce them? But big companies in particular do take the NDA stuff seriously, enough so that you always have an interesting set of discussions. When you get NDAs, so if I come back to it later, we'll ignore this slide, but in an NDA, the non-disclosure agreement, you really want to say what it is, the purpose of the disclosure. Why is someone disclosing it? And what's the use going to be made of it? And then the question in those agreements is to define what it is that's confidential. And from your perspective, if you're receiving it, you want to make sure it has to have confidential written on it. It's only written documents. Or if we have a discussion, you write it in a memo and send it to me saying, this is what we talked about and it's confidential. So I actually know what it is I'm supposed to keep confidential. And then the question is, do I have to keep it confidential forever or for some period of time? You'd like to have a time on it so that after a period of time you don't have to worry about it anymore. 3 years, 5 years, whatever. And then there's some exceptions. Well, if I have a contract with you, it says I'm going to keep your stuff confidential, and you go and tell Yoast, well, do I have to keep it confidential? So there's an exception for that. Or maybe I already knew about this. Or maybe it came out in a court order requires me to disclose something. So there's usually a bunch of exceptions in a non-disclosure agreement. But the key things are, do you actually know what it is you're agreeing to keep confidential? What period of time? And for what purpose was it disclosed? Those are the three things if you look at an agreement and they're not covering that. Yeah.
What are the penalties of breaking?
It's a contract, and like any contract, if you can show damages, you can sue for damages. So that's where it might say, I'm showing you technology for making widgets that I'm in the process of patenting, but I haven't. And now you go and disclose it, and I can't get a patent, there's a damage. The problem on damages is you really have to understand what it is. There's a classic case in English law where somebody took a package to the railroad and was sending it off, and the railroad lost it. And it turned out to be the main drive wheel of a mill that was being sent for repair. And the cost of the mill was down for months until they could get another one made. And so they sued and said, we lost all this production time and everything else. And the court said, well, wait a second. There was no indication as to what the value of this was when you, said, here, carry this for me. And so there was no real understanding of what the risk was. And we're not, so you could have told them. So the issue in a non-disclosure is, even if somebody agrees to it and then goes and breaks it, can you show what damages are? And so that's why you want to say why it's being used. This is a prototype that's going to revolutionize the world or something. So, okay, patents. Patents are the strongest of these protections in terms of the legal rights. Perhaps the strongest is the trade secret if you can keep it secret, because if nobody knows how to do it. But a patent is a federally granted right to any system or method that is new, non-obvious, and useful. And it's actually right in the Constitution saying that this system exists. But you have to apply for it, and the Patent Office actually has to grant you one. So we don't like, why do we have this system? Well, we don't like monopolies, right? So why do we give somebody a limited time monopoly, and we'll talk about what those rights are. Why would we ever give that out? And the theory is, well, because people aren't going to disclose their inventions if somebody could simply take them and run off with them. So, and it's useful to us to have those inventions in the public disclosure so other people can learn from them. And as a society, over time, we sort of build on the shoulders of the people before us. And that's the trade-off that's been made. We'll give you limited time rights in exchange for the disclosure. It's very much like real estate. And people get some misconceptions. If you own a piece of real estate, what's the fundamental right you have when you own that, other than the obligation to pay taxes? It is to keep people off the land. It's to prevent people from trespassing. It doesn't mean you actually have a right to use it. Actually, in the patent world, it's the right to prevent others from making, using, selling, or distributing or importing the patented invention. But ownership, this right is not necessarily the right to use the invention. So what does that mean? It's a right to keep people off. In terms of real estate, I might own a piece of property, and you may own property all around me. I may not actually be able to reach my piece of property without crossing over your land. But I can keep you off mine. Or maybe I need other things in order to make use of the property, like electricity or something else that I don't have. And in the patent domain, it's the same thing. So if I have the classic one I like to explain is, I've invented a vessel to hold a liquid. Let's assume nobody ever thought of that idea. You know, I observed a coconut shell catching water, and I said, oh, I can make something that can do that. And let's say I get a patent on it. And you come along and you say, wow, that's a great invention, but you know, I need to do some things to make it more commercially viable. Like maybe if it's a lot of water, I need a handle so I can lift it. Or maybe if I'm putting coffee in it, I need a handle on the side so I don't get burned. Or maybe I want to put a top on it so it won't spill. And you could get it, assuming nobody else had talked about that before, you might get a patent on the handle. So I have a patent on the cup, and you have a patent on the handle. Well, if you try to put your handle on my cup, I can prevent that. And similarly, if I tried to put a handle on my cup, if you own that patent on a handle, you could prevent that. And in fact, it's a classic thing and a strategy actually for startup companies, because patents are expensive. If you think you have a really good invention that you can get a strong patent on in talking to your patent lawyer, you know, get a good patent and then disclose to the world all the other things you could do with it to prevent other people from patenting those other things. It's called picket fencing. You can actually steal the value of a patent by patenting all of the commercial implementations of it in a way that stymies the person. So is that clear, the idea that it's a right to exclude, not a right to practice? Okay. And the claims of the patent are like the boundary of the property. So what you're really paying for in a patent is getting claims that cover things, just like a nice strong fence around the property. The duration is 20 years from the date of filing these days. Okay. Let's see, what else? Requirements, it has to be new. And you actually have to cite what's called prior art to show, if you know something that's out there, you have an obligation to disclose it to the patent office as relevant to your invention. And there's some consequences. If you fail to disclose prior art, you can actually have your patent invalidated. It has to be useful, which is usually not a problem. There's some pretty dumb inventions out there. It has to be patented subject matter. That gets into the esoteric about whether you can patent life forms or DNA, and some of these things, you know, it's angels on the head of a pin. Important, and things you'll talk with your patent lawyer. An important thing, though, is it can't have been previously sold or publicly described. So if I were to stand up here, and this would be a public disclosure, let's say, and I explained an invention that I had, and I told you how I did it. So it has to be an enabling disclosure. So you could hear me and say, oh, I get it, I could do that. Then that's an enabling disclosure. In the US, you have 1 year from the date that you do that public disclosure, 1 year in order to get a patent on file. And if you do it within the year, you're not foreclosed in getting a patent. You still have to go and make sure that the patent office agrees that it's all these other things. In the rest of the world, if you disclose before you file, you can't get a patent. So it's a really harsh thing. I was over in Istanbul with a program, a State Department program, where they're trying to build entrepreneurship capacity in primarily Muslim countries. And there was this guy from Egypt, and he had an interesting team and interesting wireless technology. And I said to him, well, do you guys have a patent application filed? And he said, oh, well, we're going to think about getting that. And I said, well, what have you disclosed? Well, he'd written 4 papers, technical papers on it. And I said, geez, you know, I without reading the papers, I don't know, but that's probably going to keep you from getting a patent any place except maybe the US. If that paper, you know, was less than a year ago, maybe you can still do it. And you could just see the guy's face, you know, collapse. So it's a thing you want to keep in mind. File before you disclose if you can.
Joe?
Yeah.
In an academic context, where is public versus private? If it's a research group, is that public? If it's a seminar for your department, is that public? If it's a class that people are paying tuition for at a private university, is that public?
Well, there are 2 parts. It's a venue where it's done, and it's the extent of the disclosure. So I could tell you that I have a great invention for anti-gravity boots and tell you how wonderful it is, and it'll hold, you know, X pounds, and it, you know, it's powered by solar stuff, and you can't figure out how I actually do it. That's not an enabling disclosure, even if I got into Yankee Stadium and did it. It's a very tricky question when you get inside, you know, smaller university settings like that, and that'll come part of this MIT owns research licensing thing that I have a whole set of slides on. But if in doubt, try not to disclose everything about how you do it. Yeah.
I was under the impression that as of 2013, the United States was going to move first in time. Move to first in time.
Yeah, that's separate from this.
Oh.
So you're right. Under the America Invents Act, the recent patent thing, before that, we were a system in which the person who first invented, as long as they made diligent process towards getting a patent, and that could even take years, would win over somebody who invented later. So, you know, two people in this room could simultaneously or, you know, near time invent the same thing. And under the old system, it was the first to invent. And that's why you had lab notebooks that you would, you know, get signed and stamped. Or if you had a really valuable thing, people would, you know, write it and sign it and, you know, send a registered letter to themselves and not open it, so they had the stamp of the post office, things like that to prove when it happened. As of, I think, March, we're switching to a first to patent system, which is actually going to be a little painful for startups and people, because big companies have the money and they can patent. The advantage of this one-year rule where I could disclose, because I might start to disclose it in order to determine whether there's market interest in what I'm doing, I wouldn't have to put the money out for the patent, and I'd have a year to figure out whether I really wanted to do this and maybe get some financing in. That's going to be harder because if somebody comes in and patents first. But they still have to be the inventor. So they can't hear about your invention and then run off and patent it. They'd have to show that they actually invented it. Now, this one-year thing for the rest of the world, we have a thing called provisional patents, which I'll talk about in a moment, that solve that a little bit.
Just off the cuff, can you give us a couple of prices on minimum cost of a patent?
I have a whole slide that's going to tell you that, okay? Because you guys are cost aware. That's good. Okay, and then the other thing is non-obvious. It has to be a non-obvious invention to one of ordinary skill in the art. Now, this is also an important one for MIT technical stuff. There was, everyone knows about venture mentoring service. I think, did we talk about that? So venture mentoring service is it's a great service here, about 120 or 30 mentors available to any member of the MIT community, staff, student, alum, who wants to get assistance on developing a venture. And there was a MIT professor who had a very interesting technology, and he was talking with his mentors, and he asserted that, I published a paper. Oh, that might be a problem. Oh, and it's, you know, it's not obvious. Well, you know, actually it is sort of obvious, is what he said. So they came over to talk to me, because what I do for VMS is I sort of do IP stuff for them. And we got to talking, and what it was the professor thought that somebody at his level of skill would find the invention obvious. And as I pressed it more, I said, this is not legal advice, because you got to go talk to a patent lawyer. But from what you're telling me, I don't think that's the standard. You know, you're up here at this cutting-edge MIT thing, and the standard is somebody of ordinary skill in the art. So you know, and in fact, they went to a patent lawyer. They determined that, in fact, I was right about that. They started the company, and within 2 years, it had been sold for $70 million. So I think he owes me something. I'm waiting for my cigar or whatever. So but it has to be not obvious to one of ordinary skill in the art. Okay. We sort of talked about this. Patents as they relate to business plans. So we've been talking about patents as allowing you to protect your invention. You also, as you start a business, have to figure out whether you're going to be infringing somebody. Who asked the infringement question? Somebody had the infringement question. So you don't even have to know a patent exists, and you can infringe it. So it's not like you have to knowingly infringe. There is something called freedom to operate opinions that you get from patent lawyers. And what that's trying to do is protect against a provision of the patent law that says if you willfully infringe, you can be liable for 3 times the damages, plus attorney's fees. So it's very typical as part of product development to have the lawyers give a freedom to operate. So they do a search, and they give you an opinion, and they say, if you do what you're saying, it's my opinion that you're not going to infringe. And if later on it turns out you do infringe, at least you're not subject to the extra damages. And then you have to figure out whether the company owns the technology. We talked about that in terms of were you working for a prior employer. If you have an independent contractor who didn't sign an invention agreement. So you want to make sure in your plan, so when you get to due diligence, you'll be able to pass due diligence. And we talked a little bit about patenting versus disclosing to prevent others as a way, because it's easy to disclose, cheap. As you'll see, patents are expensive. Yeah. It's the inventor files.
And then who gives the right to the company to use that image? Does the inventor?
The inventor would normally have, if you're a technical employee, you probably sign an invention agreement where you agreed that anything you invented would be owned by the company and you would assign it to the company. And in fact, they usually even have clauses in there. It says, and if you refuse to file it, you've given me the right to file it, the assignment for you. Yeah.
I heard an interesting thing. If you're the inventor, your name will be on the invention. You just give away the rights for it.
And it's important that the inventorship is accurate. So there have been great stories about heads of laboratories who have their name on every single patent coming out of the lab. That may not be the smartest thing in the world, because if you can't show that the head of the lab actually had some inventive contribution to what's claimed, it can invalidate the patent. Now, from what I know about Bob Langer, he actually does contribute a lot to everybody. He's very prolific, but there are many labs where it's a political thing. You know, I'm your boss, I'm going to be on the patent. Well, maybe that isn't a good idea, because maybe you'll lose the patent if you do that. Okay? Yep.
So then how do you protect yourself from that situation? How do you prove that you contributed enough?
If you're the head of the lab?
Well, any position that you have a name on the patent.
All right. Well, it's documenting what contributions were made. So there would be, in typical lab settings, you'd have lab notebooks or something that would, yeah, and you try to document it. In well-run labs, they have all these procedures under the old rule to show when they invented, but also to support in litigation that, in fact, these were the right inventors. And you can't leave somebody off. So, you know, if I'm on the outs with Yost and I said, damn, I'm not going to put him on my patent, and it turns out he actually was, again, I lose. So if it's over-inclusive or under-inclusive, I can lose in litigation.
In founding a company, people split up equity often in proportion to people's degree of relative contribution.
Yep.
And yet this patenting mechanism treats everybody as effectively equal co-inventor. And yet we know that people contribute to different degrees to the creation of a concept. There's a prime inventor, and maybe others helped. That seems inequitable. How does this get resolved?
Well, you do want to, so the way it's resolved in terms of a company where the inventors are employees is the company gets all the rights on whatever basis, and they compensate the people. The problem is when you have co-inventors without an agreement. Sometimes we'll see how MIT does it. It can be rewards, and there are a lot of reward programs. It can be just, you know, we pay more for our top inventors. You do want an agreement, though, because if you have co-inventors on something, they each have the right to exploit that invention, unless they have an agreement saying that they'll agree on doing it. But if you think about it, if Joost and I are both inventors on a patent and we don't act in concert, we can actually destroy the value of the patent, because he'll go out and try to license it exclusively to somebody. And he can't do that, because if I license it to somebody, neither of us acting alone can give an exclusive license, which presumably would have more value than, in many cases, than non-exclusive. So it's handled in a company thing because you transfer the rights to the company and the company controls. Okay. Obtaining a patent, the important thing is to look at these following things. Figuring out what to patent. And you'll see that the cost of patenting is high. So what to patent? When to file? Is there a strategy at preparing applications? And then how do you go about prosecuting? Many people say, what can we patent? And that's not the right question in a company context. It's what is it that if I get a patent on will advance my business? What has commercial value? And how would my competitors use my technology if I didn't patent it? Jonald, if he doesn't talk about it tomorrow, I'll remind him about a couple of the patents he got that were very, very strategic in why he did it. And it ended up helping them greatly. So instead of in a big company where you're rewarded for patenting, they have these invention disclosure things, and then there's a patent committee, and they try to figure out what to patent. And I can tell you from having dealt with a lot of those big companies, they really, they're doing it because it's cool technology in many cases. They don't actually connect it to their business. You don't have that luxury in a startup company. You don't have the money. So you have to think about it more strategically. In doing it, you have to figure out what this is relative to that you're thinking of patenting against prior art. And that's where my company comes in place. This is See the Forest, where you could actually search and map out patents. So for example, let's see, I can come back here to look. Let's see. This is the virtual ink patent. What we have here, this is a patent map with time in this dimension. And each of these boxes is a US patent. The left edge of the box is the issue date. The tail is the filing date. And the lines connecting them are the citation references. So when Jonald filed this patent, he cited all these other patents as prior art. And now that's something that he can, and let me see if I can make this work. So there's a live version of that map. And so here you can see at the time he filed it, actually at the time I did this map, when he filed it there were 44 patents that it cited, and these are the patents he cited as prior art. When I did the map, the 28 means there were 28 patents that cited him. I just hid them so you didn't see them on this. You're welcome to use this system. We make it available especially to MIT people. You can access the underlying text at the patent office and a few other things. And by just looking around, you can see who's in the space, et cetera, and get an idea. So it's a very quick way to process it. We use this as a way of doing IP due diligence for when we're starting up companies. Now, how do I get rid of this? So when Jonald filed his patent, it looked like that. And these were the people, they're color-coded, who was on the map. These are people in the space. And this is what it looked like several years later, where here are the companies, the patents that started to cite him. So by tracking, you use this to determine prior art to try to figure out whether something is out there. So if you do a search and you found the virtual ink patent, you might look at who it cites as a way of doing a prior art search. Any questions on that? It's See the Forest. You can go and register and give me a call if you want to get something more than that.
Past projects, you often come across patents that's issued and then dead. Someone has developed it, small startup, dies, but it's still within a 20-year horizon.
Well, you have to pay maintenance fees, so you pay a fee when it issues. In the U.S., you have to pay, these are for utility patents, the normal ones, or design patents are different. You have a window to pay it 3.5 years after it issues, 7.5, and 11.5. And this can get it really expensive. One of our clients, I couldn't believe they didn't know the answer. They said, well, how much would it cost us to maintain our portfolio for the next 10 years? And you think, well, you guys don't know that? Well, in 10 industrialized countries, we did the analysis. It was going to be $250 million just in filing fees and renewal fees, even if they never did anything. So, and often these things are things that are patented at the beginning, and they're not valid, they're not used anymore for that company. So that's why secondary markets and patents are there. So you can't tell from this whether some of these may have expired. The other thing from this map, if you see, there are 2 red lines. This is 17 years from the date of when I ran it, and the one to the left is 20 years. It used to be a patent was good for 17 years from the date it was issued, and under the rules when they changed, it's 20 years from the date of filing. So anything to the left has probably expired. So there you could practice that invention. You can't infringe an expired or a lapsed patent. So that's part of your freedom to operate. You can. Yeah, in fact, you can do it directly from there. Okay. Here's what their whole portfolio looked like when I ran it last year. These yellow shaded ones back here are Yonald's patents. And these were people that cited him. So the other thing you can do strategically going forward is to figure out, well, who's citing my patent and why? And unlike citations, you know, if I write a scientific paper, I might very well cite my professor's textbook because it's the politically good thing to do. In the patent arena, there's a consequence if you fail to cite something. And it is, if you know about it, it's deemed fraud on the patent office, and it can invalidate the patent. So these citations actually have meaning, and you can often determine, get insights by looking at who's citing things to see where technology is going, where if you're thinking I've got a technology looking for different applications, which despite what we tell you, really go, we say find a customer and then solve the customer need. We know a lot of what you do here is technology trying to find the right place to go. Brontes, for example, as Yost mentioned, ended up for dental. Nobody would have thought of that at the beginning. So keeping track of where people are citing can actually show where invention's occurring, which is sort of what we wanted to do in the patent system. Tell me the invention and other people will do it. Yeah.
Citations, you get the original patent anyway, licensing, do they have to take permission from all the citations?
They may, but let's say this Yonald patent over here is my cup, and I come along and I cite Yonald's patent for my handle. They don't infringe as separate, but if I put them together, they might. So often this can be a way of looking at, if you're a company, at who might be infringing. It can also tell you who might be in your space, who might be partners or collaborators. There's a lot of business intelligence in looking at this. And we've done a bunch of work with the National Science Foundation SBIR program in their commercialization, trying to use the patent data as a way of helping them refine their commercialization. Okay, when to file? You want to file before you lose U.S. or foreign rights. I remember I described that 1-year period. Before the public disclosure. The other way you can lose it is if you actually go to sell something before you file. There's a great case because it just doesn't seem, at first, doesn't seem right. So somebody goes and goes to a trade show and has developed a brassiere that had certain benefits or whatever. And it was actually shown at a trade show. Well, the brassiere wasn't actually shown, it was somebody wearing it. And in a court case, that was deemed to actually be offering it for sale because they were actually taking orders, even though they didn't actually disclose it. You can do R&D type things in disclosure. So if you have an airplane, terrafugia. I don't know if they patented anything on theirs, but they actually have to fly it somewhere in public. So experimental use is not deemed to be public disclosure or on sale. And you also want to file and make sure that it's in time to actually protect your product or service. This is where provisional patents applications come in. As you'll see later, the cost of utility patents can be expensive. A provisional patent came into the law and allowed you to file something, and you have 1 year from the date you file that in order to get your full application on file with all the claims. A provisional application doesn't even have to have claims in it. We've seen people take papers that were going to go to conferences, slap the cover page on, send it in. So it's cheap. The problem is it doesn't really, it has to have a meaningful description of the invention, and that's the trick. If you talk to patent lawyers, they'll say, well, you know, you're really best going through the whole process right at the beginning, because you make sure you get everything covered. And that may be true, but it's expensive, and you may just be at the beginning of your technology, and so you want to put something in, and as you learn more from customers, you'll put new features in. So when we were developing IP Vision, we had, it's a SaaS product, and we were doing release cycles every 4 to 6 weeks. And we would actually look at what we actually did and decide whether any of it was particularly useful from a commercial viewpoint, and we put a provisional application in. We would also think of things that we thought about doing during the development cycle, but decided we weren't going to do it at that time, and say, do we want to file something there? And we would do these stacked provisionals every 4 to 6 weeks, and just kept in track of when those would run out, and decide after we'd been through 5 or 6 cycles of development, okay, do we want to actually take these and combine them into a real application? So that's one thing you can do, but it has to be a meaningful disclosure. So if I say, fruit and vegetables are very good for you. That's my brilliant invention. Nobody else has done that. And I put a provisional in. And then in the course of the year, you know, I go, well, you know, protein is important too. And so now I want to, in my final patent, claim steak. Well, the question is there any way the word, what I'm trying to claim relates to that earlier description? And if it doesn't, then I don't really get the benefit of it. So that's where, you know, spending a little time doing it, but it is cheap. It does preserve your foreign applications, and think about it in the right situation doing it serially. Any questions on provisional? Okay.
So do you have a lawyer help you with that?
You don't have to, yeah. How many people have written a patent? Anybody? Yeah? Okay, so I didn't bring one here. You have to keep them locked up. They're kind of deadly. But a part of it is you have to describe the invention and the best way of doing it, and then you make sure that it is described well enough that when you claim something, you can relate it back to it. So there's a lot of sort of technical things that have to go on. And that's where the lawyers come in. So if you, from a cost viewpoint, if you go in and drop a lab notebook on the patent lawyer's desk and say, write me a patent, that's going to be really expensive. If you write up what you think your invention is, why it's an improvement over what was the motivation for why you did it and why it's better than other things, and you give a framework, then the lawyer can spend time crafting the actual claims, which that's where his or her expertise is. You know, if they were going to be a novelist, they would have been a novelist. And that can save you time and money. Okay? So that's, I basically ran through what a patent is, what it looks like. Here are your costs. This wakes everybody up. Who has costs? Here they are. I haven't updated this in a year or so, but for a full utility application, $5,000 to $15,000 is a range that most of them can be done in. Large companies trying to be efficient have been trying to drive the filing prices down because their game has been to get a lot of patents. They're getting smart about that now because they know how much it costs to maintain them. Having said that, I had a patent application that went in that ended up costing us $35,000. And you think I would have been able to figure it out. And what was happening is I didn't control the process. And so my co-founder would be calling the patent lawyer, throwing new ideas in. And I didn't know anything about it. So he was getting stuff from 2 different directions. And so instead of costing what might have been $15,000, it was $35,000. So you got to manage this stuff if you're, like everything with a team. U.S. filing fee to get the thing on file is $400 to $800. I think it's a little more. $400 for small entities, $800. The prosecution beyond the filing could be anywhere from, $5, $15. It can go as high as you want. Yeah, most of it's the lawyers. There are some filing fees. And if you're not on top of the lawyers, if you don't respond to them quickly enough and they're up against deadlines, patent lawyers are always up against deadlines because their clients don't plan ahead. So we got to respond by next Tuesday. So it's a drop everything and you write it all night and the cost goes up. Or there's a deadline. If we don't get this on file, then we deem to abandon it. So you can control this by having a good process behind it. And those filing fees for extensions of the prosecution can add up. But it's primarily you're billing by the hour. Here are some of the other foreign fees. There was a General Accounting Office study back in 2003 that said it cost between $300,000 and $500,000, depending on the nature of the invention, the field it was in, to obtain and maintain a patent in the 10 major industrialized countries if you were a small company, which has lower fees. So they can be expensive. From a startup's viewpoint, the good news is the expense isn't all at the beginning. So on a strategy where you say, I need to file some things because I'm trying to build up credibility and everything, you can defer a lot of these fees down the road. When you start going international, the fees start to mount up pretty quickly. And in fact, we abandoned a whole bunch of applications when we hit the national stage. Okay, yeah.
Maintenance fees?
They get more expensive over time. I think it's, the first one isn't much. The 11.5 year can be $4,000 or $5,000 in the U.S. In foreign countries, they're often periodic annuities, like either quarterly or annually, and you usually have to go through a local lawyer.
If you don't maintain, does that patent
It lapses.
Which means it's now no longer
Enforceable. So it's prior, well, yeah, right. In other words, if I would otherwise infringe your patent, but you let it go abandoned because you didn't pay the fee, then you can't come after me. So that's why, as companies, they'll start down a technology path and they'll switch to something else. And that's why sometimes this market in secondary patents have come up, because it might be useful to you, Yost, but not to me. And that's happening. Yeah, back.
So I have a bunch of questions about locations. First of all, how do you decide where to file your patent? Secondly, should you bother filing the patent if you're not operating in the US or in an industrialized nation where these things can be enforced?
Right.
Then the third thing is, does the enforcement depend on where you're selling your product or where your company is incorporated? So if you're incorporated in the US but operating elsewhere, how does that affect?
So good question. I should have put it in there. Patents are rights that are granted in a given geographic area, things we call countries. So if I'm going to be operating in 10 countries and I don't have patents in all 10 countries, you could go and do exactly what my invention said. Let's say I didn't file in Germany. You could read my invention, say thank you very much, and manufacture the product there. You can't import it into the US because my right in the US, if I have a patent, is to prevent you from importing, selling, making it here, so I can keep you out. You have to make some strategic decisions about where your markets are. The good news for the US, it's a big market. So for startups, it's not a bad scenario just to do the US. In biotech, it used to be, and it probably still is, I just haven't looked at it recently, is that people would start doing these filings everywhere, and then they'd sell off some of the foreign rights to a larger pharma company in exchange for money to continue research in the U.S. So does that answer it? In the U.S., you go to the U.S. Patent Office in Washington is where it's filed. Okay, yep.
Preparation of patents. For the diagrams in a drawing, is that something you need to get outside help with as well, or is that something that a technical person can do themselves and save money?
You could probably do it yourself, but there are low-cost drafts persons to do it. We're coming up just about on 7:30. I'm the only act tonight, so maybe we take a stretch. What I'm going to cover here, we've got a little bit more on university licensing, and we'll be out of the IP space, and we'll be moving into founders agreements, equity, and financing. But why don't we, can we keep it to like 5 or so minutes? And start about 7:35, is that good? Great. Yes.
Next class? At the very beginning of the next class?
Next class. Okay, we'll do that. Good. Okay, everyone sign the attendance sheet, etc. Okay, I'm going to... bunch of questions anticipated the next set of slides, which and then we'll be finished with the IP stuff. University licensing, always a classic set of issues. The federal government does a lot of research. Back before the Bayh-Dole Act in 1980, the federal government would patent inventions that came from the research that they funded. And Bayh-Dole came along and said, well, really, you haven't done a very good job. There have only been 30,000 patents for all this money we're investing in research at the federal level. And shouldn't we decentralize this and put it back to where the inventions are occurring? And so Bayh-Dole gave the right, and in fact the obligations, to universities to manage this process of patenting. So they gave it to universities, and that has caused a dramatic acceleration in commercialization. It requires them to retain ownership of innovations created under government funding, file patents on invention arising from those, give licensing preference to small business. That's good for your companies. The government actually can get a royalty-free license. They're supposed to develop programs to commercialize the patents and share royalties with the inventors. So that leads to the MIT Technology Licensing Office. And the mission stated there is to facilitate the transfer of technology and what's happened in the labs to commercial success. And secondarily, it's to generate revenue. Now, in many other universities, the primary goal seems to be to generate revenue. But at least MIT claims that's not the case. There is an MIT ownership policy of IP. And what it's, there's actually, you can get it at the TLO, Technology Licensing Office site. MIT owns the patent or copyright if significant use was made of MIT facilities. So if you're doing something in an Athena machine, that's not significant. But if you're using a laboratory and maybe the nuclear facility, if MIT administered funds were used, and that would be like under sponsored research. But the sponsored research thing gets tricky because they enter into agreements with each of the sponsors about what rights there are. So depending on what lab you're in, that may affect you. Now, MIT says MIT will actually waive an invention to an inventor if there are no sponsor rights. I should footnote all of this with the Media Lab, which is a whole other situation. If there's no significant use of MIT facilities, no funds used, and no plans to use MIT facilities to reduce it to practice. So if you have a question about whether you have rights to it, it is possible to go to the Technology Licensing Office and actually get them to write, "We waive any rights," which is very helpful when you can point it to the investors and say, "See, we're clean on it." Now, these are things where there's been government funding or sponsored research. But this is a very vibrant intellectual community. So there are a lot of people come up with ideas that are not related directly to any research. So MIT actually has a process by which it will voluntarily prosecute, as it's called. That means obtain a patent. And if MIT accepts this, you have to go pitch them. They'll basically front the patent costs, and they'll do it just as if it were an MIT invention. And this has actually helped the TLO do a lot more than otherwise would happen. Now, if you, let's say you did some research and it's clearly an MIT patent. MIT was unique. A lot of the technology licensing offices were licensing to big companies. And it was the revelation at MIT that a lot of innovation occurs with small companies. And so they became more friendly in trying to figure out how do we work with small companies. I can get $100,000 from DuPont, but I can't from a startup. How does that work? Well, one of the things they do is they often will give an option to the startup, an option for 6 months to a year to license the technology. So now this allows you to go and talk to your potential investors and say, here's our great idea, here's how we're going to commercialize it, and we have an option from MIT to get it. And so the investors know you'll actually be able to do something. So it's a nice way of having that work out. Here are some typical license financial terms. Now this is taken from Steve Brown's work a few years ago. I haven't checked with him to update it. So take these only as sort of guidance. Typically, for a license with no equity in the company, that is where the MIT is not taking ownership of any equity, the fees would be issue fees. When the patent issues, you might have to pay $50,000 to $100,000 to MIT, or $150,000. Maintenance fees to keep the patents alive, they don't have that exceed more than a certain percentage of your run rate for the product. You have to actually agree to do something. You can't actually license it and never do anything. They have a right to pull it back. Now, that sounds worse than it is. The reality is once they've licensed you and it sits on the shelf for 2 or 3 years, it's sort of lost value anyway. But you have to agree to actually work with the invention. Royalty is a percentage of sales, anywhere from 3 to 5%. I'm going to show you some other tables where they vary depending on the technology. And the question is, what is sales? That's a whole set of issues. If I make a little widget that goes into an iPhone, do I get a percentage of the price of the iPhone? And so there's some other things that have to be negotiated. You agree, if you take the license, that you'll pay the patent costs, and you're not required to actually sponsor research at MIT. Now, if it's with equity, they drop the issue fees down. Sometimes they drop the royalties. And they will, in lieu of that, take equity. And typical startup equity terms are single digits, the percentage of equity, maintained through the first major round of financing. I think one company that I was involved in starting, we actually had probably the highest equity we gave for a lot of strategic reasons. MIT owned 20% of the company. But that was for very specific reasons that we wanted them to have that much. They have proportional anti-dilution on their equity. After that, I'm going to explain what anti-dilution is later on. It means how do I get protected when more stock is issued. And MIT may actually have a right to participate in future rounds of financing. MIT does have an endowment. They do invest. These are typical royalty rates for university patents. They vary by industry because of the nature of what's there. At the high end, maybe pharmaceuticals, given the nature of what they are, the higher percentage. And in some of the materials things, lower percentage. But these are some of the historic rates that have been out there. People heard of the Cohen-Boyer patent? Any of you bio people? This was the basic gene splicing patent that launched the biotech revolution. It was Professors Cohen and Boyer out of Stanford. Stanford made $250 million licensing that patent. And the way they did it was you would get a letter saying, here's a patent we think you may need to take a license. And our license terms are $10,000 issuance fee up front for the license. And if you ever get a product into the market based on the gene splicing, then and only then do you pay a royalty. And it would start at 0.5% and go down. And so for a biotech executive saying, gee, I can't even call my lawyer for $10,000, right? So a lot of people took these things, and over time, and by the way, if I ever get a product in the market, my investors are going to be happy, I'm going to be happy, and 0.5%, who cares? So that's one way of thinking about some of these royalties. What does MIT do with it, with the royalties?
The same thing applies if an entrepreneur comes to the MIT. You know that there are many inventions at the MIT labs.
Yeah.
So an entrepreneur comes and wants to commercialize one of these inventions. So the same thing applies.
Same type of thing. Okay. So what does MIT do with the royalties? Well, what it does is it, first of all, it takes 15% off the top for administrative, at least last time I checked. They deduct out-of-pocket costs, usually the patent costs and expenses that haven't been assumed under the license. And then they distribute 1/3 of that equally among the inventors. And then they split the other parts, you can ignore some of that other things, basically between the department and the school, or for the university in general. So it's an interesting one, especially if you have a professor who has an interesting invention, really doesn't want to go commercialize it. They patent it, and he can get something for it, the department. And it has encouraged a lot of people to come forward and do that. Okay, so that sort of covers most of our IP things. Some people asked it at break, and I meant to mention it. It takes somewhere between 2 to 4 years for patents to be issued from the time you file. It can take that long. I haven't seen them. I've seen some as very infrequently less than a year, but usually 2 to 4 or longer. Patent applications are published in the US 18 months after they're filed. So unless you agree you're not going to file it anyplace else in the world, in which case you can keep it private until the patent issues. Provisionals aren't published at all. Nobody ever sees the light of day on a provisional. But if you file the regular application, 18 months after, it'll pop up. And it may or may not have even been examined at that point. So again, from your due diligence, you'll see these applications. You don't know whether they're actually going to issue. They also provide information about who's doing what in the space. This can help your commercialization or other strategy. Any final questions on IP? I've beaten you to death? Okay. All right, the next part, legal entity. Here I'm going to cut through a lot of things and say for most of the people that are doing companies that we'll see here, if they're lifestyle business, if you don't really need any capital, there are a whole bunch of other things we can talk about, LLCs and things. But for a lot of the basic, I need to raise some money, it's going to be a corporation. And the reason is corporations provide limited liability for the owners of the corporation, so your investors. Often the choice is Delaware, and that's because Delaware has a very advanced corporate law. So there's a lot of certainty in what the documents mean. They also have a separate court that only hears corporate shareholder cases. And so there's developed expertise. Now, if your business is located in Massachusetts and you incorporate in Delaware, like my company, we're deemed to be a foreign corporation in Massachusetts, so we have to actually file something in Massachusetts as a foreign corporation. Somebody said when to do this thing, and the issue is you should do it sooner rather than later to avoid partner liability, among other things. Before you incorporate, if Joost and I are working on a project together, and we're planning to do a company, we're engaging in this activity with the intention of profiting from it, we are actually general partners under the law, even if we never wrote anything down. And general partners have unlimited liability. That means all of my assets and all of Joost's assets. And We're jointly and severally, so you could sue either one of us. And there are a whole bunch of other consequences. So if you really get serious about moving forward, you want to be incorporating earlier to avoid the kind of partner liability. Minimize personal taxes. I'm going to talk to you about Section 83, which is a really important thing. We're going to talk about S elections. When you incorporate an estate. You are taxed at the federal level, and you may be taxed at the state level. At the federal level, corporations are deemed to be C corporations, which is the subchapter C of the tax code, unless you qualify and elect to be an S corporation, which basically eliminates one layer of tax, and I'll show you an example of that. And you have to observe corporate formalities. If you do the corporate thing, make sure you keep records, you sign in the corporate name, etc. Here's an example of subchapter S, taxation. So what we're talking about here is the taxation of the company. On the left side is a standard corporation like Google. They have a net profit before taxes after all their activities of, say, $100,000. There's a corporate tax. Let's say the rate is 35%. I'm not sure what the rates are going to be under all this new stuff, but directionally it's the same. Then that yields $65,000 after they pay the corporate tax. And back when I did this, the individual tax rate could be as low as 15%, and the net cash to the owners would be $55,000, or an effective tax rate of almost 45%. With subchapter S, if you qualify, no corporate tax, and therefore it's only the individual tax, and that was the advantage of subchapter S. You have to be fewer than 100 shareholders. They all have to be human beings, which means venture capitalists cannot. And yes, venture capitalists as people are human beings, but they invest through partnerships which are not deemed to be human beings for tax purposes. And if those of you would want to connect that a venture capitalist isn't a human being in the way you laughed, that's your choice. It's not mine. And as we get to the immigration issue here, all of the shareholders, there can be no non-resident alien shareholders. What does that mean? A French citizen living in Paris, if that person were to become a shareholder of your company, you would not be able to be a subchapter S company. And the immigration law thing is such a morass. Anyway, sub S is good. And the question is why? Don't most startups have losses? So how do I avoid taxes on losses? Well, it used to be those losses could flow through to your investors. So I'd put $100,000 in, and I'd take my share of the losses. That's been cut back quite a bit, but it's really the exit, because when the company gets sold, many of the kind of companies that you'll deal with will be acquired by buying the assets of the company. And you'll pay next to nothing for the assets. What's the assets of a software company? It's not much. And you're going to sell it for up here. So they're going to buy that, and they will not have to pay taxes in between. DIVA, which was the first spin-off of the Media Lab, Digital Video Applications, said, if we can't get venture money, we're never going to go anywhere. And I said, well, humor me. Let's just be a subchapter S. And they never did get venture money. But at the end of the day, they saved $4 or $5 million in taxes by doing sub S. So sub S is a good thing to think about, and is sort of the default aspect. Now, Section 83 is something you should remember big time, because this is a very unusual part of the tax code, and it could cost you a lot of money. The rule is, if you receive property in connection with providing services, then you have ordinary income. That's like the income you get when you get a salary, 35% plus, equal to the fair market value of the property minus what you paid. So that's your ordinary income. So the example is, I like your idea. I say I'll give you $1 million for half the company. Let's set it up. Sound like a good deal? Well, think about it. The property you would get if we don't have a corporation in place already is stock. That's deemed to be property. And you're going to provide services. I'm the investor. So what's the fair market value of the 50% of the company you get if we set it up today? Come on, math. Well, if I pay $1 million for half the company, what's the other half of the company worth? Could be $1 million, or it could be I put $1 million in and ideas are a dime a dozen, so really the only value is $1 million, but that's still $500,000. So, and you paid how much for it, assuming you hadn't invested otherwise? 0? So you have anywhere between $500,000 and $1 million of taxable income, taxed at 35 or 40%. So thank you very much. You can pay $200,000 to the government. Sounds like a good deal? Okay, so, and there's the $1 million example. So how do you avoid this? You need to separate. The reason in my example is that I came in and I'm going to give you $1 million and I'm going to get stock, and that's when you get stock. And they're happy to get the same time. So the trick is to separate in time when you get the stock and when I get the stock. So if you incorporate and issue the stock today, it's going to take you 4 to 6 months before I get ready to give you the $1 million. And since ideas are a dime a dozen, that's the value of your stock at the beginning. And you can sort of get out of this trap at that point. But if you go to the lawyer on Friday saying, I got a term sheet and we're going to close next week, how do you explain what happened? How did the value go from 0 to $1 million in 3 days? So the trick is do it early. And the question is, why doesn't stock, if you do incorporate, why doesn't stock get issued in time? Well, sometimes people are just too busy, and sometimes we don't know who should get what. And we'll talk a little bit about the criteria there. But I want you to think of this diagram. And let's think of a company that's a technology company in which the team consists of one or more technical people and one or more business people. And my graph here, can you see it there? Relative importance is the vertical scale, and time is the horizontal scale. If I would ask you, where would you put the letter T representing the relative importance of the technology people? Where would you put it on at the beginning? High. And over time, what happens? It's going to go down in relative importance. And what about the business people? They're going to be sort of at the bottom, because until the technology works, we don't really have a business. And over time, their relative importance is going to go up. And it doesn't matter whether they cross or not, it's the direction. So you get a lot of interesting things that happen at the beginning unless you understand this dynamic. The technical people are working their tail off trying to make this thing happen. The business people are saying, well, you know, I'm thinking about what we're going to do. I got my day job. You know, when are you going to get the technology done? And now we're talking about how we're going to divvy up the equity. It's a hard discussion in any event, but where one person's working really hard, and oh, by the way, it was probably the technical person's idea, you can see the dynamics. And I actually struggled with this in a company that I was involved in founding, and realized that this was happening and had to take the business people back to Sloan, and we spent a whole day trying to get them back on track to think about, you know, how we're going to build value in the company, because, you know, they were sitting around doing nothing, complaining about the technical people who were bossing them around saying, I need more equipment, and the whole dynamics was just terrible. Yeah. Mm-hmm. Yep.
What was the tax rate 35% applied to? Like when you say it's fair market value, that's exactly the same. In this example, isn't that exactly the same as how much the company raised money from outside investor? But that's not exactly the fair.
Well, the question is what is the fair market value? And the issue is when there's an investor putting cash on the table, it's pretty easy to measure what the fair market value of a stock that I'm paying cash for is. And no, it's what you're getting. So in my case, if if our deal is 50-50, I'm putting in $1 million for half the company and you're getting the other half, then either the fair market value of your half is $1 million, because if I paid $1 million for my half, isn't your half worth $1 million? Or you could say, well, no, it's only $500,000, because if we liquidate the company, there's really only cash to be distributed. But in any event, those are still two big numbers.
So the tax, well, when is the tax collected?
It's owed at the time you, oh, that's even a better problem. Normally, it's owed at the time you get it.
So the moment that you give me $500 million for as investment into equity into my firm.
Yeah.
And the moment I get this money from you, I need to pay the government tax.
If you're getting stock at the same time. If you incorporate today, and we roll ahead 4 or 5 months, and now I give you, and you've issued stock to yourself, so you own 100% of the company, and I come along and I say, here's my $1 million, I would like to own half the company. You already have your stock. It was worth whatever it was when you issued your stock today, which, you know, no money in the company, no customers, whatever, it's low value. And I'm putting my $1 million in, but you already have your stock. The problem is, if we form the company at the same time, and you're getting your stock at the same time I'm putting money in, then how do you argue that your stock isn't worth somehow based on how much money I'm putting in? So that's the key part. The takeaway is incorporate early if you're serious about the venture. Now, there's some cost to incorporating, so I wouldn't just willy-nilly incorporate. But if you're, you think you've got something and you're going to make a serious effort to write a plan and go get money, you got to get all this stuff done early, or you walk right into this. The longer the better. Months would be great. Now, if a patent issue's in here, or maybe you get some approval, there are a lot of things that could show why the value went up. But what typically happens is people don't address it until right at the last moment, and then they fall into this.
So how often does the IRS shaft entrepreneurs on this?
Well, if you're doing it right, they don't go after you. Now, the other part, when you said when does the tax, this is the part where you have to also think about it. The rule is that the tax is measured at the date you get the property, unless the property is subject to a substantial risk of forfeiture. That's what the code says. What does that mean? Well, when I give you $1 million, I like your plan. I give you $1 million. I've basically done everything that I said I would do. I mean, I'm going to help you and everything, but I gave you the money. And you haven't really done anything yet except write a nice plan. And so I'm thinking, well, geez, how do I know you're going to keep working on it? So typically, we'll talk about vesting your stock. And I have a little slide, we'll talk a little bit more about it. If you're vesting the stock, you don't measure this until the stock vests. Vesting means that if you leave the company, you lose the stock or some portion of it, typically a time-based vesting. So under this rule, if you got vesting there, you don't measure it at the time you get the stock, you measure it when the vesting ends. And if everything's going fine, here's the $1 million, your stock's vesting, the company value is going up, and now your stock vests, it's not the $1 million problem, it could be a $10 million problem. And there's some cases where the CFO, a company hired its first CFO after 3 rounds of financing. He came in to file what's called an 83B election that says, I know my stock's vesting, I want to take the tax hit now, which is what you do. And he found out that nobody had ever filed an 83B election. The company had raised $50 million, and everybody had ticking time bombs because their stock was vesting. Lawsuits went everywhere, the accountants, the lawyers, everything. So it is a real problem. It's an easy one to avoid by incorporating early and getting the stock out. But that's why this thing saying, why do people not do this? Because we don't really get around to issuing the stock because of a whole bunch of things exacerbated by this in the case of technology-based companies. Yeah.
Let's say you incorporate a company, and then shortly before you raise money or so, you bring on a new hire or something.
Right.
You give him stock, you issue him stock. What does that, this new person, does he then, and then let's say a week later you raise money from venture capitalist, does he then have to pay, or how does it work?
Yeah. Well, there are a couple things, and the problem with this is it sort of gets seamless. The typical investment that the venture guys will make is what's called preferred stock, and we'll talk about that. And so the preferred stock comes in and it has preferences over the common. So the common, which is typically what you give to the founders and employees, is not worth as much as the preferred. And in fact, in first round venture deals, the rule of thumb is that if the price of the preferred is like $1 a share, the equivalent cost of the common is anywhere from 5 to 10% of that value. So what does that mean? So in my case, where I put my $1 million in and I want to get my $1 million out first, and then after that we split 50-50, for the finance people in the audience, if I have put $1 million in and I have $1 million preference, in other words, I get my money out first, what does the common look like in terms of a financial instrument? It's an option on the future value of the company to the extent it's above $1 million. And so option pricing might lead you to think that an option with an unlimited duration, with an unlimited upside would have a value, and then maybe 5 or 10%. Somebody would pay 5 or 10% for that right out of the box, and then volatility and all of that for those finance wizards. There's a whole bunch of things, but conceptually that's what happens. So when the venture guys come in, you can still give the stock outright to the employees at lower price. At some point, it gets too expensive to do that, and then you switch to options. And options are taxed differently. As a founder, you want to get your stock early and at low cost because everything becomes capital gains above that. And you can control when you're taxed. With options, you can't quite, but at least you don't have to pay it right up front. So we'll hopefully touch on that before the end. Is that sort of answer? Message founders, get your stock early. If it's vesting, file your 83B elections. Do that well in advance of getting funding, and everything should work out just fine, except, of course, your product still has to work and all that stuff. Yep.
So a lot of that, I think, is arcane combination of tax code meets precedents.
Yep.
Is this the kind of stuff that you as a founding team are counting on your lawyer to give you good advice on?
If you get your lawyer early enough. So that becomes the issue here. When do you get a lawyer on board and all of that stuff? But if you go out and don't talk to them and you're writing your plan and now you get a term sheet and you go, oh, geez, we better incorporate. Pat McGovern tells a great story, the founder of IDG, tells a great story how he went to the customer and he got a check for $50,000 and he didn't have a bank account because he wasn't incorporated, so he decided he better incorporate. So the tendency, if you don't pay attention to this and you're very successful in everything else you do, you walk into the lawyer's office and you just hit with a buzzsaw. So my message is be aware of this, sort of plan it a little bit ahead, make sure you're talking to somebody early enough on so you don't have that problem. Because it is arcane. 83 is a very weird provision. No other place can I think of, do you ever get taxed if you don't actually receive something? I mean, if you don't sell it, right? I buy a building, I manage it, I sell it. I'm taxed when I sell it. I go to work for a company, I get a paycheck, I get cash, they take money out, I grumble, but at least I got cash. This happens because I get a piece of paper. I haven't sold it. And I got to pay tax on it? It's a very weird provision. So anyway. Okay, people, founders memo, roles, expectations, equity. So the message is to sort out relationships among founders up front. In a closely held corporation, the stockholders owe each other what's called a fiduciary duty. You really, if I'm a shareholder in Google, I don't owe anybody a responsibility. It's a big company, But if I'm a shareholder in a small company, we all have obligations to treat each other fairly. So you do have to take it somewhat seriously. Questions you have to figure out is who sits on the board if you incorporate. That may not be the whole team. Who's going to hold what positions and functional titles. Understanding this could all change when the investors come in. You're going to want to put restrictions on stock transfers in what might be a stockholder agreement. This is all stuff. Did you read the founders memo in the materials? I really would do that. I wrote that after spending a week early on in my career with 3 teams coming in from MIT, startup teams, and we spent probably 4 hours with each team trying to sort out, the questions they needed to ask themselves. And I was very happy that we had these very interesting companies. But I said, this is crazy. I've just spent 12 hours of my time for which they don't have the money to pay me. There's got to be a better way. And I went home and wrote the first draft of a founder's memo. And thereafter, I would give people a memo and say, before you come in, read this and at least start to talk about it. And so when you spend time with me, if I'm charging you, it's to try to solve the problem, not trying to get you the information. So in the memo, they talk about things like restrictions. What happens if somebody is leaving or selling stock? We might need a stockholder agreement to preserve the S corporation status, so we can't transfer stock to a French citizen that would destroy it. I had a company once where somebody got, one of the shareholders of the founding team got so pissed off that he decided he was going to nuke the S status. And he didn't care. He was just going to hit everyone with it. And there was no agreement in place. So things like that type of thing. Intramural disputes, how are you going to handle them? And basically, see the founder's memo is the best advice I can give to go into the real details on that. Let me switch over to equity, founder equity splits. How it's split up is always the big question. And it's really culture and negotiation. And at one extreme, people heard of Keenan Systems. So Keenan was a Sloan professor, set up a company doing information stuff for telephone companies, I guess. Was about 10 years or something. He sells it to Lucent for $1 billion. He owned 100% of the company. Ended up giving a $100 million gift to MIT later on. His people were highly compensated. They got cash. They didn't get equity. That's the way he chose to run the company. It worked well. I don't know if he'd do it again, but it certainly turned out well. In the software area, the culture tends to be more, well, everyone should have some equity. The real issue with equity is, do people even know what it means? The first job I had out of MIT was a spin-off of Pew Roberts, Ed Roberts' company. And we had the 3rd floor of a triple-decker up in Cambridge. I was number 3 employee and showed up for work. And there was one bathroom on the 1st floor under the stairs, those old buildings, you got the little bathroom tucked in there. So eventually, after a bunch of coffee, I have to go down there. And so I open the door, and I start to walk in. The entire walls of the little bathroom are covered in real, live, honest-to-goodness stock certificates that presumably are worth about as much as wallpaper, because why would they be in there? And so that's the issue. Is this piece of paper going to be worth anything? And when people have gone through the cycle and they realize that stock can actually buy me a car, a boat, a house, it motivates. But for a lot of people, they don't really know what it means. And so you have to ask, as part of your culture, around founders, presumably you understand that, but as you move, what's your broad policy going to be on that? The kind of things to think about in the equity splits are, what's the value of past contributions? What's the value of the future contributions? If it's the technology person working hard for the next 6 months and nobody else is going to join, that might be worth more than equal splitting. And what's going to happen over the next 4 years? Who's going to be giving up what and committing? I had, there was one professor, PhD student team that in deciding how they were going to split up their own equity, went through an exercise that said, what am I committing to do and what am I giving up? The professor had 1 day a week that he could consult, that had a consulting rate, that he was going to give up. He had a reputation that was going on the line to be a part of it. The PhD student was giving up any career, at least in the short run, for academic or tenure. That had a value. He was giving up going to work for a company that would pay him a lot more. And only by sitting down and writing down what everyone was doing that they could actually, they were very data-driven. A lot of MIT people tend to be data-driven. And that helped them sort of frame the discussion about who was doing what and what was appropriate. And always remember, both for founders and then ownership of IP can, of course, be a key part of it. Internal equity is something you always have to think about in any kind of compensation. You know, if you're not treating people with particular attributes the same, it can be very divisive, and you have to assume things are going to get out. Let's see. Let me sort of morph over. Other than that, I'm not sure. There's some good blogs and things about, and I think it was mentioned yesterday by Katie, the chapter 6 of Founder's Dilemma has some different philosophies of how to split up founder's stock. So rather than do that all here, I would commend those things to you. This is partly, I took some of Charlie's slides and redid them, philosophy on team building. So now we're talking both about founders and going into the rest of the team. And the assertion that the work to be completed is always much, much greater than the work that's been done. So as you're trying to figure out who's entitled to what, keep that in mind. Compensate for both risk and sacrifice, and make sure the systems actually reward you for actually getting to the end zone. I think a lot of people think that all stock should vest. You know, in a founder, if you have 3 founders, 4 founders, you don't know how many of you are actually going to be there a year from now. Things happen. And if somebody's got stock and they can walk away with it, that stock you don't have that you can use to entice someone else in. So, and at the beginning, it's a good time to have a discussion because usually you don't know who's going to be on which end of that. If you wait until it actually happens, then we know who's leaving, and it becomes a lot more personal. So I think we can have a discussion around what is our philosophy about if somebody leaves, what should happen. And the other reason to have vesting is investors are going to want it. And you might as well put something in place that you can live with. Otherwise, you're going to have a whole set of discussions, and you might not like what they come up with. Okay. Basically, the same kind of thing relating to employees. Here, as we get further away from the founding of the company and the risk goes out of what the company's doing, that should change the amount of equity compensation. So who gets the pie and how big are the shares? In a typical venture deal, if I looked at all the deals I've ever seen, first round venture, substitute first major round, you know, the thing that's really going to get you going, it is, in my experience, been typical that the amount set aside for employees is 2 to 3 years worth of equity compensation, and that's usually 12 to 18% of the company. And the way you come at this, you remember Charlie, I'll show you an example, how he did his headcount rollout. You use that also to calibrate your budget for stock. The amount can be less than that if your team is fully formed. In other words, if you've got all the team there and they're getting founding shares, maybe the pool is less than that. If you need to round the team out, it's going to, could be on the high end of that. In an option pool or equity pool, it could be key employees. You have to decide whether it's going to go to everybody. Again, that's a philosophy question. Does the receptionist, if you ever have a receptionist, get part of that? It might very well be. Directors often, and maybe consultants, depending on what you're doing. And determining the award signs, it's really a market. You got to look at this constantly. Salary.com, I haven't looked at it recently, used to have some interesting comparative data about both equity awards that people are getting, and it just becomes touch point. I'm chairman of a comp committee for a public company, so we look at a whole bunch of things, and you can really get carried away. I think for yours, it's just you got to look at the market you're competing again. This was Charlie's slide. I thought it would be useful here again. How much ownership after a couple rounds of financing would not be unusual. I like to think, if you look at the big picture, a success would be a company that went public or was acquired. In other words, there was a big financial reward. And if the founders own a third, if the investors owned a third, and if the employees owned a third, I think everyone would be couldn't really complain too much. That's sort of my ideal model. It rarely happens. But I've seen companies go public where founders own over 50%, and I've seen it where they own less than 10%, of the whole founding team. This was Charlie's example, if you remember, and that's his head count, and you can see after 2 rounds what the percentage ownership is. You want to model that out and always be thinking about, compared to the philosophy you have for compensation, what the numbers are going to be. Because again, you're competing, as you get further along down the road, you're competing, the founders are one thing, but as you're bringing other people in, you're competing with the rest of the world. So Microsoft worries about this, that its people are going to go and work for Google or Facebook. In the Valley, it's not unheard of for somebody to come to work in the morning, quit at noon, and go to work for a company across the parking lot in the afternoon. So you have to do that. Let's see. Okay, I'm going to run through different forms of equity compensation. That answers the question about what do you do with the employee who's coming in later. I'm going to talk about restricted stock and 2 types of options, one called incentive stock options and the other called non-qualified. So restricted stock is stock that's sold or granted outright today, usually when the value is low, and it starts, you own it. Actually, you do have voting rights and rights to get, typically you have voting stock, and rights to get information. And it starts the tax and SEC holding periods when you actually own it. That's a benefit of restricted. It's usually subject to vesting and buyback. So, you're given stock. It can either be just directly, here's 1,000 shares. If you leave the company, some of them come back. The typical vesting these days tends to be a 4-year period. The first year is called the cliff, 25%. So if you leave before the end of the first year, you lose everything. At the first year, you get 25% you can keep. You've earned it. And then typically every month thereafter, for the next 3 years, the remaining vests on a linear basis. Some people used to do it quarterly or semi-annual, but then you get into the problem, well, you fired me right before my big vesting was occurred, and there have been cases on that. So it tends to be monthly vesting. In some cases, the company might buy back the stock if you actually paid money for it. The 83B election, we talked about the 83 problem. So not only do we want to make sure to get the stock early, but even if I get the stock today, and we put vesting on it, and then 6 months from now, in comes the investor. Because the vesting delays the time when I have to realize the tax, I can make what's called an 83B election that says, I want to take all my tax hit here at the beginning. And so if you get vesting stock, make sure you file the 83B election. It has to be done within 30 days of the date you get it. So that's another. Remember 83, remember 83B, and you'll be in good shape. Yep.
So if your funds got vesting set up, before you have investment, how much do you have to pay for that 83B election? Do you pay anything on it? Do you pay much?
It's what fair market value of the property received less what you paid.
So you can take that ahead of time.
Right.
It's nothing to do with how the vesting schedule is in terms of how much you pay on the 83B.
So let's say the value of the company was objectively the shares were worth a penny. I do an 83B, I recognize a penny of income. If I have vesting and I don't make the 83B and it runs up to $10, when it finally vests, that's my income. So you want to do the 83B right then at the beginning. Yep.
Is that even a possibility for foreigners?
If you're subject to U.S. tax, yeah. Once you do the 83B election, it's like you own the stock outright, and other tax rules come in. Incentive stock options. So at some point, this gets too expensive. Even if you gave me the stock, the value is too high. And I don't really want to leave my job, come work for your company, and get stock and then have to pay tax on it. So what do? Incentive stock options. Those are options that comply with certain tax requirements. They can only be issued to employees of corporations. Another reason why to incorporate. There's no tax when you get the option. So here's options on 10,000 shares of Facebook. No tax at all. If I, except for this alternative minimum tax, if I exercise the option at some point, I don't get taxed on it. And if I hold the stock and don't sell it until it's been 2 years from the date I got the option, and 1 year, at least 1 year from the date of exercise, then it's all capital gains. So that could be good. The problem with alternative minimum tax, and this would only really hit people with large amounts of options, is that if you fall into the alternative minimum tax, you actually get taxed on effectively when you exercise. And during the internet bubble, there were a whole bunch of people that ended up exercising options, having to pay tax on it, and then the stock crashed afterwards, and it was a real disaster as the bubble was bursting. Again, that has to be, and the grant has to be at fair market value. So whatever the value of the stock is today, here's an option to purchase X shares. And the option can last for up to 10 years. Typically, it vests over some period of time, 4 years, so you can exercise a certain amount every time. And when it comes time to exercise, if it's $1 a share today, when that stock is $10 a share and you exercise, you pay the $1 to exercise, you get a piece of paper worth $10. If you hold that for at least a year after that, then you have capital gains on that. Yep.
So when, let's say we all have an equity dilution, new invested money in, does that dilute restricted stock as well, or just common equity and?
No, it dilutes the actual stock issued. And in fact, when new money comes in, new stock is issued, it will also dilute the effective stock that you get for the option. Right, because that's 1,000 shares. You can get 1,000 shares if you pay this much. And now we bring in a new person, and now we have twice as many shares. Your option's still for 1,000.
So does restricted stock normally fall into the preferred equity or common equity?
It's common. So the restricted stock thing is traditionally would be, this is what you do early on because of the tax consequences if it's too expensive. And it's just like you're buying the stock cheap. Because of accounting rules for public companies, it's become more fashionable for public companies to actually be giving restricted stock to people. And there's a whole bunch of reasons why that makes sense. But for startups, the basic message is get the stock early if you can. Make sure you file the 83B election if you vest. And as you're growing the company, when it gets too expensive to take that tax hit, you switch over and you give options to people. And if you have an option, there's no reason to exercise it. I mean, you don't have a right to vote. You don't have a right to information because you're not really a stockholder. But you can control when the hit is. I mean, I would never exercise an option unless there's an event on the other side. Like the company's going public and I can exercise and sell, or it's being acquired. Or the third thing, which I bumped into last year, my option was expiring. I had a 10-year option that was expiring that was well in the money. And if I didn't exercise it, I was going to leave a lot of money on the table. So I had to exercise it and pay a bunch of money to exercise and pay a bunch of tax. But at the end of the day, I still had value in it. Now, non-qualified stocks options is another type of options. These you can give to anybody. And the rules are a little bit different, except unless you're giving the options at very low prices. If you give them at fair market value, there's no problem. There's no tax on the grant of the option, of a non-qualified option, or an NQO, or when it vests. But there is ordinary income when you exercise it. And that was the kind of option I had, because I got this as being a director. I was not an employee, so I couldn't have an ISO. And so when I exercised, the difference between the value on the date I exercised and the amount of my exercise price, that was ordinary income, and I had to recognize that and pay tax on it. So you typically use these for non-employees. Vesting. When you think about vesting, you're really saying, I'm giving you this equity because I expect you to do something. And what you really want is the result, right? I want the product out the door. You're my engineering team. When the product goes out the door, you vest. And that's sort of performance-based or milestone-based. The problem is it's really impractical because, as we know, the product may shift, the business may shift, and so you spend a lot of time trying to write the conditions on which this option ought to vest or the stock vests, and it doesn't work. So it tends to fall back to calendar vesting, which says, all right, I get it. We're all in the boat. As long as you're rowing hard, you'll vest, because we know the journey is going to change. And so that's the typical. If you figure that you can actually specify the event you want to have happen, it's a perfectly valid thing, but you got to manage it a little bit differently. Other questions that come: what happens to options or stock that are vesting if we get acquired? And there are a whole bunch of schools of thought. Some people accelerate the vesting. It says if we get acquired, we'll treat this as being fully vested, so you can participate in the sale and get stock. Other people say, no, you don't really want to do that because the acquirer is going to want to retain people, so they're going to have to put other money on the table. And if you just gave people a windfall when they got acquired, it makes it harder for the acquirer to put more money on the table, and you're just lowering. He's not going to pay as much. He's going to lower the acquisition price. So there's an active debate on when things should vest and how accelerate investing. So think about that if you ever get in a position and have discussions going ahead. Again, a lot of this stuff is to have a little red flags in your head about, I think I heard about this. Forfeiture and expiration of rights. If an employee leaves, what happens? Well, under ISOs, they have to exercise within 90 days. So if you ever have an option in a company and you leave, you better make sure you exercise it. Otherwise, you're not going to have anything. What happens if I give you options and you've been bad? You've been breaching company confidences? Do I have something in the agreement that says I can take back your rights, et cetera? Things to think about. And your lawyer should be thinking about it, but I want you to be aware of it in case they don't mention it. Buyback issues. If let's say I fully vest and I leave the company. And this is again in the founder's memo. Is our philosophy is you earned it, you get to keep it, even and forever? Or do you get to keep it to the value that was achieved while you were here, or maybe for a year after? Again, a basic philosophical question. Because somebody early on, the company may sputter for a few years, and somebody leaves or fully vested, and then they finally get the right business model and the company takes off. But they haven't been there to do anything. Again, it's a philosophy question of how you want to run it. Okay, timeline on people. I did circle here, probably can't see it. Independent directors. I put it out somewhere around the first round, but I would really, as part of the people thing, you really ought to think about independent directors maybe even earlier than that. The board meeting that I was at today, there are 3 outside independent directors. There are 2 major investors on the board. There are a whole bunch of corporate investors that have visitation rights. But these outside directors, 2 of the independent directors, have been there since before the first round and were instrumental not only in helping position the round, but when some difficulties happened between the investors and the founders, the independent directors had the confidence of both sides to be able to negotiate that through. So that's all part of your external team that you want to think about. Okay, moving along. Financing. pre-outside financing, securities laws, and then there's some initial things. So I'm going to run through securities laws here. These are important. You can get royally screwed if you don't pay attention to them. First of all, whatever you do on any equity type things, make sure you paper them up so it's very clear what happened. We have lots of stories of people thinking they had a deal, and they tend to come out of the woodwork at the absolutely worst time. Litigation filed right before a round of financing is not a good thing. Even if it's a piece of paper, hopefully a full set of documents. But these sort of things like, well, I'll give you some stock, or, you'll have, God forbid, you'll have 10% of the company, and does that mean forever, or 10% when we found? There have been all these kinds of things. So be very careful about promising ownership of a company. That's really the kind of thing, if you don't have a lawyer sitting around somewhere, you're asking for trouble. If you use the business plan really to sell securities, it presents a whole bunch of problems if you're going beyond VCs and corporate investors. And the reason is the Securities Act of 1933, which is the governing statute here, says if you offer, not even sell, securities, you have to register that offering with the Securities and Exchange Commission. That's like going public. Unless there's an exemption from registration, and the typical ones are what we call private placements. And this is where you do actually need to bring in an experienced securities lawyer. You can do a private place. What they're worried about really, which is interesting when we come back to look at crowdfunding, is the idea that these are disclosure statutes. And the concern was that the so-called widows and orphans were being sold stock without adequate protection. If you think about it, what is stock? It's a piece of paper. I mean, how do you know what's the company unless the company has to tell you what it is? And so that's the whole registration process, enough information that you know what's happening, because you can't go and knock on the door of Facebook and say, I'm going to buy stock in your company. I'm thinking about it. Let me look through the files. It doesn't work. So there's a whole procedure. Private placements say, look, if we have sophisticated investors and we have some disclosure, we can sell these things without a full registration process. Typically, you can have up to, in private placements, you can have up to 35 what are called non-accredited investors. You can have an unlimited number of accredited investors. Under the current rules, accredited investors is somebody, you can do it a number of ways. It's $200,000 of annual income for the last 2 years. If you're single or with a spouse, $300,000 combined income for the last 2 years. Or if you have $1 million net worth, not including your principal residence. You're deemed to be big enough that you can afford to get advice. And therefore, you can sell to those people without having to go through the registration process. And you can sell even up to 35 non-accrediteds. But you still have disclosure obligations. And that's why you want to include risk factors. So if you look at the business plan, despite what Steve said last night, business plan to me says, here, I have an opportunity. Here's how I'm going to approach that opportunity. Here's why I think it's going to have a big result. Here are the resources I need to do it. Here's my plan. And I never put in a business plan, because it could be deemed to be an offer, something that says, and I'm offering to sell 10% of the company for $2 million, because that's an offer. What I use as a plan is a talking document, and I figure out what the interest is of the people that I'm talking to. When I think I have enough interest in it, then I can take the securities lawyer and wrap around it the other kind of disclosures I need, the risk factors and other things that will protect it. So I for one, don't want to ever see in a business plan what the offer is. You can talk about it separately. And the idea that I'm going to tell you what I'm willing to sell, I mean, really it's a negotiation with the investors. And most of the time, unless you're a serial entrepreneur where they're clamoring to get after you, they're going to be dictating the price more than you're going to be dictating it. You can dictate whether you accept or not, but it's going to be more, they're going to put their price down. There's not a whole lot of negotiation. So now with the crowd, did I put that in here? Private placements. Rule 10b-5 says you can't make, not only in your disclosures can you not state something, tell a lie, but you can't omit to say something that reasonable people would think would be important. So since it's an asymmetry of information, the company knows more than I know. And so their obligation is don't lie to me. And by the way, tell me something, don't misstate something or omit to state something that I should know about. That's where you get into legends and control, numbering of documents. If you remember the first day I showed you the cover page. And Regulation D is the actual regulation where private placements, safe harbors are. And there's a Form D filing. And in fact, if you want to find out, the way all these bloggers find out who's getting funded is they look at the SEC Form D filings. And that's how they tell. In private placements, the idea is you're private, you're not making public announcements. There is something called blue sky laws. There are comparable state statutes that piggyback on it. Now, what happens if you don't follow these rules? Well, there are a couple things. First of all, it's criminal. So theoretically, you could go to jail. But the other thing is there's a rescission right. What does that mean? In my articles in Boston Business Journal and in the reading, I talk about a tragedy in 3 acts about how this screwed up for a company. But if I sell you securities and I don't go through all of this stuff, later on you can come back and say, you didn't comply, I want my money back. And not only from the company, but from you personally. So you're giving them a free option, and you have personal liability. So you really don't want to do that. And that's where I said don't offer securities in a plan. Now, having said all of that, I don't know where this crowdfunding thing is coming out. You've heard about it, everyone?
You mean equity crowdfunding?
Equity crowdfunding, yeah. So we know that Kickstarter is one way to raise money to get the money to build a product or something, and you're not giving away equity, but it has to be used to build the product. So the same concept of crowdfunding investment did pass, and there's legislation. The SEC is trying to figure out what it means, because it sort of goes against the old grain of widows and orphans. There are a whole bunch of issues that would take us too long to even, I don't even know the answers to now, but would professional venture people want to get in a company that's heavily funded by crowdfunding people? Because you have sophisticated investors and non-sophisticated investors could be the dichotomy. So who you take money from becomes very important. If you need to take a lot of money, you don't want to string along a bunch of small people with big people because they don't mesh very well. And they can actually, I've seen venture guys say, well, we don't want to get involved. That company has too many shareholders. We can't deal with it. But not everyone needs venture. So it could be very valuable, but we don't yet know the final rules on it. And I just put it here as a placeholder. Again, the slides will be there. Okay, what are we doing? Let me see if I can. I thought this was an interesting one. Have people seen this? There should be a sound on this. Do we have sound?
Most young companies need money, which may or may not come as a big surprise, but they do. The number one source they get money from is from their own savings. Whether it's a few $100s or even thousands of dollars, that's what we tend to tap first. And a lot of companies don't get money from any other place. They get money from their own savings, and then after that, they're lucky enough to be cash flow positive. They're profitable. So we talk a lot as if all companies require all sorts of external capital, and the reality is that more than half of young companies get all their funding from a combination of founder savings and then cash flow from the business, and we're out of here. Next up on the list is another one that catches, I think, people by surprise, and that's credit cards. Almost every young company you can think of, to one degree or another, was funded on credit cards. And it is the single largest source of capital for young companies after founder savings. And then the next place where they tend to get money is from friends and family. After I've tapped out my credit card and I've used up all my savings, I turn to people I know and say, hey, will you help me? And that's the third biggest source of capital. And then the next place is banks. And the banks are a totally weird situation because with banks, they get a lot of attention, but they actually fund very, very few young companies. But it's not their fault. You have to think about the way bank lending works and how shareholders want banks to lend. They want them to lend money against secured assets. And young companies don't have any security. They have nothing to secure it against. And the joke in the industry is you can get all the bank funding you want as a start.
As long as you don't. All right. Come on.
As long as you don't need it.
There we go.
And then the last piece is venture capitalists. They get the lion's share of the attention.
You can actually...
which in some ways is warranted. You know, your Googles and Apples and FedExes and many others all have venture capital money inside of them. But the reality is, and this is from Kaufman Research, less than 20% of the fastest growing companies in the United States took any venture money. And that's not because the VCs wouldn't give it to them. It's because they didn't want it or didn't need it, because they had all those other sources. I don't need money, and I certainly don't need money on these terms. Because, you know, venture capitalists, unlike banks, they don't lend against secured assets. They give you money in exchange for shares. So they take some of your company away. So my answer is if you don't need it, definitely don't get it. There's no question the venture industry has become staid. The irony is it's intended to fund disruption, and yet it's an industry that had become complacent. And interestingly, over the last 5 or 6 years, we've seen the emergence of other mechanisms for funding, like AngelList, like these kinds of peer-to-peer funding sources, as people increasingly provide capital in smaller amounts, but more people doing it directly. Having said all of that, though, venture capitalists are hugely important for those young companies that don't have access to bank money, but are growth companies. They have the prospect of being a $5 million or a $10 million company in a couple of years, and they need that growth capital to get there quickly. So it's a race. And the way you play the race is by getting money from people like venture capitalists who give you the money so you can compete with other people who are racing as fast as you are. If you can run a company off cash flow and some combination of credit card, your own savings, and friends and family, you know, Bob's your uncle, run.
He's changing his ink pen here.
Run. You know, keep all the equity because, you know, there's no better thing than being in full control of your own destiny.
Okay, I thought you would find that an interesting 3-minute video. If I could kill it here, let's see. Or maybe not. All right. We're coming pretty much up. I was going to run through a couple things about actual investments. For those of you at Sloan, you don't need to see this, but for people that don't understand capital structure, I put a slide in here. Please take a look at it, talking about if you think of who gets what, and you start peeling money off who gets what at a time, you start at the top, which is secured debt. You go all the way down to the bottom, which is common stock. Common stock is what's left over after everyone else gets paid. If it's a raw startup, it's maybe worth nothing. If it's Microsoft, you're the richest guy in the world. And within that, you can play in your investment of who gets what. On top of that are warrants, which are rights to purchase stock, options, which are another right to purchase stock, and convertibles, things that you buy that can convert from one into another. And I'll just run through this for people. Take a look at this. As you look at a life of a company, at the beginning, a startup is primarily all common stock. And as you take on more money, you start to see preferred stock, maybe some debt. An LBO, leveraged buyout, has a lot more capital structure layers in it. And Microsoft looks pretty much like that. Still a lot of common stock and debt. Now, for early stage companies, it's become pretty fashionable recently to use convertible note financing. Traditionally, it was a way you bridged from one round of financing to another, where an existing investor said, okay, it's time to go out and do another round, and we want to bring in another investor, but we don't have them lined up yet, so I'm going to give you some money. It'll convert into whatever the price is when we bring the new guy in. It's being used more now. It's in the startup phase because it can be done quickly, less expensively, and it avoids the valuation issues. You really don't know how much to value a company at the beginning necessarily. And there's a tendency to, if you're an investor, you try to value it too low because you want more of the company, you think there's more risk. And if you're an entrepreneur, you think it's worth more. So you're a little bit imbalanced. So the convertible is a way to span those. It says, I'm going to give you some money, and it's going to convert into the securities that we're going to issue when we actually get the real money. And to make that attractive to you, we're going to give you a discount. And often that can be for every month that the note is out there, you can buy, it'll convert at a price. Instead of a $1 price, it may be 95 cents. We'll buy one share. And then 2 months, it's 90 cents. So you get a few extra shares in the process. Pros and cons, there's some good discussion at this at startupcompanylawyer.com, which I'd recommend. Here's an example of a note, convertible note financing. You can see the ideas. It's $25K per investor. It's going to be a qualified financing, which is what we're looking for, is preferred stock with at least $1 million. And we're going to convert this note into the preferred stock, in this case at 80%. This was an example of a convertible note document at Wilson Sonsini. They have a number of things there. And Goodwin Procter, another one of the law firms, has a website called foundersworkbench.com if you want to go and look at some of the legal documents and things. I commend both of those to you. Timeline. I was going to run through the major elements of later stage funding. We are running up on time. I'm happy to keep going till I finish. It'll probably take another 10 minutes or so. The slides will be up on the website. If people need to go, feel free to do that. But I think you might be interested. So if you look at these term sheets you're going to get, they look awfully daunting. They have all these different terms and conditions, and they just go on and on. And what I thought I'd do is break it down into the 4 main deal elements that you're going to talk to investors about. And that is a preferred return. The investors are looking for that. They're trying to protect their valuation and their position in the company. They need, if they're professional investors, they actually have to manage the investment, and then they're also worried about how they're going to get their money out. So if we look at it that way, here's how an investor, especially a VC, thinks about why a preferred return. He's doing everything when he puts the money in, and the entrepreneur hasn't done anything yet in the first round. If that's the mindset. And as a result, the VC wants to get the money out first. His money comes out first. And the instrument they typically choose is called a convertible preferred stock. It's preferred in a couple ways. One is dividends. Now, most companies, startup companies, don't have cash to pay dividends. Dividends, when you have good cash flow. But what the preferred stock does is they have what's called an accumulating dividend. So whether or not we declare it, I'm going to accumulate this dividend, and if we ever liquidate the company, I get it at that point. Or if you ever declare a dividend on the common, you got to pay me my portion. And then the second part is liquidation. I get a preferred return on liquidation. Here's an example. Series A preferred has a liquidation preference such that proceeds on a merger, sale, or liquidation will first be paid to the Series A. Now, there are 2 types of liquidation preferences. One is a straight one, which says, and I'm assuming here this is a convertible preferred, which is the typical document. One says, look, I put $1 million in. I get the first $1 million out. Or since it converts, I can either take the $1 million and be done with it, or I can convert and take it as if I were common. That's called a straight liquidation preference. And that's actually a good one from the entrepreneur's viewpoint. The participating preferred, sometimes I call a double dip, says, okay, I want my $1 million first, and then we're going to split anything above that. So they get 2 bites at the apple. They get their money back, and then they participate on the upside. And this is an example of straight versus participating. On the left side, we're putting in $5 million in for 30% of the company. And if the sales price of the company is $25 million, the non-participating preferred can either take the $5 million preference, which leaves the common with 20, or if it's participating, they take the $5 million, leaving 20, and then they take 30% of the 20, so they get $11 million. So you can see, at least in this simple example, if you're an investor, why you'd want participating preferred. But the question for you, which is a better deal? In case A, founders sell 40% of the company for $5 million of convertible preferred with a $5 million liquidation preference and no participating rights. So 40% of the company for that, or 33% of the company for $5 million with participating preferred. Anybody have a feeling which is which? Well, I run a little chart here to look at it. The top is the straight preferred, or the non-participating, and the bottom is the participating. And it really depends on how big the company is. At low sale prices for the company, you would prefer to have had the participating, I'm sorry, as a founder, you'd prefer to have the straight preferred, because the participating takes so much more value out of the company at the early, if the sell price is low. If the sale price is going to be high, the difference sort of goes away. And here it turns out that if you were going to sell a company for $35 million, you'd be sort of indifferent between which of these you had. So it's just something to look at the math and think about. And when does this all happen? Well, it's called a liquidation event. So if we dissolve the company, if the company gets sold, that's when this might kick in. Okay, the second part of the element was, how do I protect my valuation and my position going forward? And there's sort of 2 ways that's done. One is anti-dilution protection, and one is approval rights. And in combination with conversion, that's where anti-dilution kicks in. So if we sell 1,000 shares of the company at a valuation of $1 million, and then next year we sell another 1,000 shares at $10 million, then we've diluted the number of shares held by the earlier people as a percentage of all the shares has gone down. So numerically we're diluted, but we're not diluted from a value viewpoint. Our value's gone up. So what anti-dilution says, look, if I buy in and it turns out the value of what I get has gone down, then I want more. And that's what anti-dilution protection is. And so it goes in conjunction with the conversion rights. So if I convert my preferred, that's when I calculate how many shares of common I get. Or if I'm forced dilution, there may be some percentage of the preferred that can force the conversion. Or sometime if you go public, it converts then, because the public markets don't really want preferred stock. It starts off with a conversion ratio of 1:1. In other words, I pay whatever price it was for the preferred. If I convert, I get the same number of shares of common. And then it adjusts from there. You know what, are you still interested in this? Yeah? Okay. Highlights, okay. So there are 2 types of conversion. One is called weighted average. That's what you want as an entrepreneur. It says that if I'm selling some more shares and they're a less price that you paid, I'm going to give you a little bit extra. And there's a formula for it. The full ratchet says if you sell even one share at a price less than I paid, all of my stock converts at that price. That's a big slam down, right? So I put $1 million in, get 1 million shares, and you sell one share at a price less than mine. So let's say I pay $1, and you sell one share to Yoast for 50 cents. Now my conversion ratio price goes from $1 to 50 cents. I get twice as many shares. So as an entrepreneur, you don't want a full ratchet if you can avoid it. And this is an example of it in the materials. And all of this is in the venture capital terms on the resource page.